Good afternoon, everyone. Allison Scobber here with Consolidated Planning Group, and we are happy to be here today with Anne Shevlin in her law office, and she's going to be talking to us today about turning 18 and things that we need to keep in consideration. So we're happy to be partnering with her again. We were just talking that it doesn't, time flies, but then again, it seems like yesterday that we were just having a webinar with Anne. So we're happy that she's back with us and her firm is in the San Antonio area. I always just like to start with a few housekeeping items first. If this is your very first time um, attending one of our webinars, welcome. We are very, very glad that you're here. If you have been attending for many, many years, we're glad that you come back. We always aim to offer great content where within the course of an hour, you can take away really good nuggets that you can implement in your family and help you on your journey with your loved one with a disability. So we are in webinar mode today, which means that we can't see you or hear you, but we know you're there. We're glad that you're here. I've got the questions were printed. I have those from the chat box, and we're going to take questions throughout. So if you sent a question in, I have them. And if you have any questions as we're going throughout the presentation today, we ask you that just put those in the chat box for us today. So just to share a little bit about CPG for those of you that are here and hearing this for the very first time, Consolidated Planning Group is a holistic special needs financial planning firm. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy, Carter Special Needs Consultants. Our whole firm is nuanced and helping families plan for the future of a loved one that has a disability, keeping in mind the rules and the guidelines as it relates to public benefits such as SSI and Medicaid waivers, so many other topics that we talk about all the time. What we do is very different than what Anne does. Anne doesn't do what we do. We're the money. How much money do I need to fund the special needs trust? Who's going to care for my child when I'm gone? What are those residential housing options? What does that look like? How do I retire, stay retired, and still have enough money to fund that special needs trust, a wedding for the other kid, and college for the other two? We kind of help put all that together. And people like Anne, they're your legal documents. They're the legal questions, the paper, the wills, the trust, the guardianship, alternatives to guardianship. They're going to do those things. So we often get calls for things that Anne does, and she gets calls for things that we do. And the truth is that we work closely together on these things, but neither of us do the other person's job. And it's really, really important whether you work with us or you work with somebody else, that you work with a specialist that's specifically nuanced and working with people that have disabilities and that need to preserve eligibility for state and federally funded programs. So we do want to encourage you on that. And the other thing that I always like to mention is that, a lot of times people put this I don't know, in a box, special needs planning, financial planning, retirement planning, and it really intersects. Okay. There are different components to each, but as parents or caregivers for a loved one with a disability, ultimately we're in charge of funding our retirement, but we're also in charge of paying for that child's care. Might be an adult child, it might be a very adult child, right? And we're also in charge of funding that special needs trust when we're gone, that's going to pay for their future care. So I think it's really important to look at those things. You're going to see this little Consolidated Planning Group flower in the left-hand corner right here. That is what you'll see if you look up the Consolidated Planning Group YouTube channel. There are over 600 webinars on planning for special needs. If you can think of a topic, I am quite sure that we've done it. And then the other thing that I would like to say is if you can think of a topic that we haven't done that you would really like more information on, please send those in to us because we aim to add new content all the time and are specifically interested in your suggestions on that. Okay. And I'm going to have you take it away. Thank you so much for being here. And let's dive right in. This turning 18 is a little scary for a lot of people. And they say that the years go by quick, the days are long, but the years go by quick. And it's like, but they're starting their freshman year and you think, gosh, I have all this time. and you seriously just blink and they're 18 years old. It's crazy. So tell us a little bit about your firm, where you're located, and then we're going to dive right in.
Sure. Thanks, Allison. So, my name is Anne Shevlin. I am an attorney in San Antonio. I practice in Bexar County, and the bulk of my practice is family law and also guardianship for special needs youth. So, this is what I do all day, every day. And I'd like to thank everybody for taking time out of their busy schedules to join us today. One of the biggest transitions that families of children with disabilities face occurs when that child turns 18. It is scary, right? Many parents spend years advocating for their child in school, making medical decisions, attending therapy appointments, coordinating services, and then suddenly on their 18th birthday, the law turns that child into an adult and everything changes. And so, for many families, that can be frightening. And parents often call me with questions like, will I still be able to talk to my child's doctors? Can I still attend ARD meetings? What happens if my child signs something that they don't understand? And then the big one, do I need a guardianship? So today's presentation is designed to answer those questions and help you to understand the legal options that are available. And one thing that I want everyone to remember as we go through this is that every individual is different, and a diagnosis on its own does not determine which option is best for you or your family. The law focuses on what each person can and cannot do. And some adults may need very little assistance, and others with the same exact diagnosis may require significant support. So, my goal is always to find the least restrictive option that still provides protection for your child. When people call my office, oftentimes they'll start by saying, my child has autism or my child has Down syndrome. And do I need to have a guardianship? And my answer is always that it depends, right? Um, One adult may be able to attend college or work part time. Another may not be able to communicate about basic needs or make decisions about medical treatment. And that's why we look at functional abilities, right? And generally speaking, you have four options when it comes to guardianship. The first is always the default, right? You can do nothing and just hope that everything works out. The second option is to use supported decision making agreements. The third is powers of attorney. And then the fourth is guardianship. And there are two types of that: guardianship of the person only, and guardianship of the person plus the estate. And so I'm going to discuss each of those so that you can kind of understand better where your child fits and what might be best appropriate for them. So the first option, doing nothing, right? For some adults, doing nothing is perfectly appropriate, right? But families need to understand the consequences of that choice. The biggest surprise for most families is the loss of access on 18th birthday. So imagine your child goes to the doctor. The doctor may not discuss treatment with you unless your child gives permission. And then, depending on what it is that they're discussing, your child may be embarrassed about it. They may not want you in the room. They may not want you to know what's happening. And so that can be very scary. Same if your child is hospitalized, the hospital may not share information with you. If your child's receiving paperwork from Social Security or Medicaid or some other government agency and they don't mention it to you, that can happen, right? And even though parents, you've always handled those things for your kids at 18, the law treats you differently or treats your child differently because now they're an adult. And so that can cause a lot of confusion for people. Same as if you've attended ARD meetings every year, once your child is 18, you are going to discover that your right to participate changes, and it's up to your child if they want to have you in the room. And now, that doesn't mean that every school is going to immediately exclude parents. Sometimes they will continue to work closely with you, but legally, the ultimate decision making authority is going to switch to the student after their 18th birthday, right? And I have seen situations where schools will say, you're eligible to continue until you're 24, or you can graduate. What would you like to do? And of course, mom and dad are saying, let's get as much education as possible. And the student is saying, I'd like to graduate. Thanks. Right. And so if you're not in position as guardian, you don't get to make that choice. And so that's how we get into trouble. The supported decision-making agreement is one of the best alternatives to guardianship. Think of it as a formal recognition that somebody needs help understanding information, but they don't need someone else to make the decisions for them, right? So the young adult is keeping all their legal rights, but they have a supporter that's helping them to gather information, to explain options, to discuss consequences of those options. For example, you may help review medical information before an appointment, or maybe help your youth understand a lease agreement, right? But the point is, the key is that the youth is the one who remains the decision maker, and you're just there in a supportive role. A lot of families like this option because it respects the independence of the youth, but still provides support to them. It's also nice because there's no court involvement, there's no hearing, there's no reporting requirements, the cost is very low. But what's negative about it is that it can be revoked by either child, and without court supervision, things can kind of go off the rails pretty quickly. So if your child no longer wants your assistance, they can just tear that agreement up and off they go, right? Powers of attorney are another tool that families will consider. It's a little bit older option because since the supported decision-making agreement came into existence, I personally think it fits your situation a little bit better, but you can use a medical power of attorney for assistance in providing healthcare decisions, and then a financial power of attorney to help address any kind of financial issues that come up. Those documents can be very useful and very powerful as long as your youth is able to understand what they mean and what they're signing. Um, and so they're going to remain in control of their affairs, but when needed, you can still sign on their behalf, right? But same, the individual can change their mind about you being their power of attorney, and they can revoke that at any time. And so there is a little bit of risk there. And sometimes, if the youth isn't able to understand the documents, or they're not really cooperative with following your advice, then power of attorney is not the best choice, and a guardianship may be necessary.
I want to
Guardian,
pause on this for the power of
yeah,
attorney because we are believers that the power of attorney, the power of attorney, the healthcare power of attorney, HIPAA release really go nicely alongside of that supported decision-making agreement. I personally am also a believer of these powers of attorney, healthcare power of attorney, HIPAA release are all documents that if you're sending a kid off to college, you should probably have for your neurotypical kids. It's conversations that you should have with aging people in your life, making sure that these documents are in place. But I will say that we've definitely seen, because our kids will sign whatever we tell them to, most of them, right?
yeah.
So I have seen where parents have had their kids that did not have capacity sign these documents. And can you talk to them about the risk of that, or what could happen as a result of when we have somebody sign something that they really don't have the capacity to understand what they're signing?
Sure. I mean, I'm surprised that they were able to have someone sign that doesn't have capacity. I suppose if it was a DIY situation, or you had a notary that wasn't really paying attention, it could happen, but it's not valid. If the person doesn't understand and they don't have capacity to sign it, it's just a piece of paper, and really it's not even worth the paper that it's printed on. So I would be very nervous about that. But to clarify, it doesn't the youth doesn't have to be able to read it independently and understand everything. Normally, what I'll do is bring them in to my office alone, one on one, and talk to them and just make sure that they understand the concept. And if I can tell that they do and that they want to sign it, oftentimes we'll go forward. But it is a little bit risky if it's a close call, right? And so I think sometimes it's good to have the medical professionals get involved and give us an opinion about whether or not there's capacity to sign those documents. Ah, so guardianship. I like to think of guardianship as the last resort because it removes rights from an individual, right? It doesn't mean that it's a bad thing. In many situations, it's the only option, and it's absolutely necessary, but it exists to protect people who can't protect themselves. Um, the court will appoint a guardian who is legally authorized to make decisions for the ward, which means the ward is no longer able to make those decisions for themselves legally. It's not just a piece of paper, it's a process, right? It goes on for the rest of that person's life, and the court is supervising it. So the guardian is going to have certain duties. The ward has some rights, and then the court is overseeing. And every year, an annual report is required because the court is keeping track of this. And the goal is to protect the ward, and they take that responsibility very seriously. Um, One of the things that is often misunderstood about guardianship is how we define incapacity, right? So many people assume that just because their child or loved one has a diagnosis, that guardianship will automatically be granted. And that's not really how the law in Texas works, right? The court is not deciding whether someone has autism or has Down syndrome or some other diagnosis. What they're deciding is whether they are able to make decisions for themselves and care for themselves. And the Texas Estate Code defines an incapacitated adult as someone who is substantially unable to provide for their basic needs, right? Or care for their physical health, manage their financial affairs. And the important phrase there is that they're substantially unable to do it. So the court is going to be looking at practical, real world functioning. They're going to be asking, can the person understand medical recommendations? Can they recognize danger? Can they manage money? Can they manage money without being exploited? Can they obtain their own food, clothing, and shelter? Those are the kinds of questions that the court is going to be considering. For example, I've worked with adults who can hold a conversation, they can use a cell phone, they can participate out in the real world socially, but they have no concept of money or contracts like leases, no idea what goes on in a medical setting. And so, because of that, the court is going to find that those people, those youth, are incapacitated for just certain purposes. So they may not be fully incapacitated. And then there are other people I've met who have very serious diagnoses, and yet they're able to function independently. And I'll just tell them that they don't need a guardianship, right? So we're always focusing on the individual's abilities and not on their label or their diagnosis. As far as guardianship goes, there are two types. There's guardianship of the person only, and guardianship of the person and the estate. So, if you're guardian of the person, you will be making decisions about health care, living arrangements, education, services, and other personal type decisions. When we add in the guardian of the estate, we're adding in the ability to manage money and property. So most people aren't going to need that guardianship of the estate because their child is just receiving SSI and has limited assets. However, if there is money involved, perhaps your child has inherited money or receives a settlement in a lawsuit, or maybe they've got other property, then a guardianship of the estate may be necessary. Another possibility is to turn to somebody like CPG and ask for a special needs trust, right? So that we can structure it so that the assets don't affect eligibility for services. And so when I meet with families, I'll spend a pretty good amount of time with them just discussing which of these types of guardianship are actually needed, because we don't want to have more authority and take more rights away than necessary. So,
Just wanted to mention because there's always confusion of this guardianship of the estate in Texas, because other states do require a guardianship of the estate. A lot of times there's other states that do the guardianship of the person and the estate simultaneously. Is kind of just how it goes, but it's not necessary in Texas because of that $20,000 asset limit. But I think I want to just clarify. that let's just say for a moment that somebody has millions of dollars in a special needs trust. You don't need a guardianship of the estate either because it's inside the confines of a special needs trust. Let's say you got $50,000 sitting in an ABLE account. You don't need guardianship of the estate in Texas when the money is sitting in the right accounts. So the guardianship of the estate can be oftentimes, most of the time, avoided. But I just want to give clarity because sometimes people start feeling like, gosh, when I set up that special needs trust, I thought I was doing everything right. Now I need a guardianship of the estate. And then because we serve people all across the United States, not just in Texas, every state is different. When it starts coming down to what the state laws are for guardianship, special needs trust, all that kind of stuff, it is state specific. So I just wanted to mention that for anybody that's listening to this out of state, okay?
Sure. And people may be wondering, why not just get guardianship of the person and the estate just to be safe, right? To make sure all my bases are covered. And the reason that we don't want to do that is there's additional requirements to qualify to become the guardian of the estate. There's additional expense involved with getting bond issued if you are guardian of the estate. And so, really, it's better to get the guardianship that fits your situation as opposed to just getting everything, right? But when is the guardianship actually appropriate? So, if the individual cannot safely care for themselves or make important decisions, that's when we start talking about guardianship. And the key word is that safety, right? Can they make decisions without putting themselves at significant risk? Oftentimes, if an individual cannot understand the purpose of their medication or they can't follow doctor's instructions, then we should be thinking about guardianship. If a person's not able to recognize when something is a scam, if they're repeatedly giving money to people online, then guardianship again, it may be necessary to protect them. If they're not able to communicate about basic medical symptoms or understand emergency situations, again, guardianship. But needing help with those things is not the same as being incapacitated. And most of us need help with something from time to time, right? The question is whether they can still make and communicate informed decisions. And so um, there are several indicators that suggest when guardianship should be explored. For example,
I want to talk
does
about a parent, like, so if a parent has a kid, because to me there are some litmus tests, and I know you're going to talk about this.
Mhm.
And we've joked around that one could argue that all kids that are 18 should probably be under guardianship. I mean, it's a joke. Not true. Um, but like if we have a child who has capacity issues, like I think of myself, and if I said, if we all died today, would it be okay for the kid to handle everything themselves? Bills, feeding themselves, getting them to appointments, doing whatever they needed to do? And to me, that's like a simple thing. If we all died today, what would we do? Or would that kid be okay? And if the answer is, oh, absolutely not, this kid can't even be left alone for more than 5 minutes or something like that. My message is you got to have an intentional conversation with an attorney about that, because I think I feel that with the state, and they've been the least restrictive, most appropriate, which I am in agreement with, but I think a lot of people have leaned to the least restrictive, and it is no longer appropriate. And so if they ask themselves those types of questions, then that might mean that a conversation about a partial guardianship, or guardianship might be necessary. Do you agree with that?
I do. And I think that the question, what would happen, if we died tomorrow, is a very good litmus test for whether there should be a guardianship or not, right? Because that's the easiest way to think of it in your mind about, like, can my child understand the medical risks or benefits? Can they make these financial decisions? And so it is a nice way to kind of distill it down into one simple question. But yeah. nothing is ever that simple, right?
We had a family, and we actually did when we did a webinar of like when everything goes wrong.
Mhm.
We had a family whose parents died. The kid parents both died in short order.
Right.
And um basically there was a cousin from out of state that was kind of in charge now, but everything was a mess. I mean, like as far as like, everything from the public benefits, from the Medicaid waiver, and people that were trying to help because this adult with a disability was basically left to his own devices when the mom died suddenly. And then people were trying to get here from out of state to get to him. So, anyway, just thinking about those things and having the plan B, and it's not something to be scared of or anything, but being real with the answers to those questions I think is going to help any legal professional guide you in the right direction. And I think the other thing is sometimes people are really afraid, even though they may know in their heart of hearts that their child actually is a candidate for guardianship or partial guardianship. They don't want to take their rights away. They want their child to be able to drive, or they don't, want to take their right to vote or other things away. So sometimes because of that need, or sometimes also people don't want to do guardianship because they may have a loved one that has violent tendencies, and they're afraid if they have a kid under guardianship that does something bad, that they're going to be held liable for that. So can you address those things?
Sure. I actually have a slide later about the liability of a guardian. So I'm going to wait on that one. But just in terms of the appropriateness and when people are asking themselves, do we need to do it? Do we not need to do it? I would say there's some clear lines, right? If you're dealing with a youth who can't manage medications, if they can't manage finances, right? They can't make decisions, or if they're just completely nonverbal, right? And so they're kind of withdrawn from the world. I would say those are clues, not for certain, but pretty strong indicators and clues that we're dealing with someone who may be more appropriately under guardianship. Same if they've gone through the SSI process and they've been found to be eligible, I think that's another clue, right? And I always ask in my intake appointments about what the school background is of the youth because I can tell. So if they're in regular education with a co-teacher, but for the most part, they're just fitting in with all the other kids and taking care of business, they're probably going to be able to do the supported decision making, right? Or the powers of attorney. But if they are in a separate program for life skills or for kids with autism or kids with emotional issues, that's another indicator to me that they need a little bit more support and protection. And so that's when I start to think about guardianship. And then, of course, anybody with serious special medical needs, I would say I start to think about pretty seriously because we need to take those very seriously and be cautious and make sure that decisions are made by people who understand them. So for me, that's a big clue.
I
In
want
terms
to
of, go
I
ahead.
want to talk about for those families that have a loved one with serious mental health issues, but maybe they don't have an intellectual disability. I know that's kind of a slippery slope, but can you address that? Because I think it's a real issue for a lot of families.
Sure. And I think mental health issues are the absolute most challenging ones to deal with on so many levels because in guardianship, what we're looking at is does someone need help with their day to day activities, right? And so if your youth is compliant with medications and they're great, they may not look like they need guardianship. But then if they go off of their meds and things kind of fall apart, all of a sudden they do need to have that assistance. And so it's a little bit of a moving target because what I've seen is where I get the call when things are at their worst. And we begin the guardianship process, which can take 6 months or more. And then by the time we get to the end, that person's back on their meds and they look great. And so we go to court and the judge will deny the guardianship. Everyone breathes a sigh of relief. The person goes back off their meds, everything falls apart, and we repeat the whole cycle. So that's definitely a challenge. And unfortunately, I don't have an answer for that, but I do. note that as a difficulty, right? If we're dealing with something in the mental health realm.
One question that we got is like, if you have a person that is under guardianship and then later the guardianship is no longer needed, they've grown, they've matured, things have changed, material change in circumstances, can that guardianship, be canceled or something less restrictive in the future?
Yes, absolutely. And I think there's a slide about that in a little bit farther on, but yes, it can. And it can be either fully revoked or certain rights can be restored. So, for sure, guardianship is something that evolves over time. And definitely know that you're going to be checking in with the court. And if it's not needed anymore, they're going to take away the guardianship.
This
Um,
is kind of a question, but it's a good one. It's kind of in the scope, kind of not. As far as how could we protect our child with communication difficulties in the event that they get pulled over or questioned by law enforcement? And I actually know this one personally. I have adult kids with disabilities. And through all states and that driver's license or ID process with the DPS or whatever agency does the driver's license, there's a spot on there on that application, or you can go in and have it amended. Is there any medical considerations? So if you have a kid that it has autism and communication difficulties, or you have a kid that has, reactive disorder and in stressful situations and they lose their mind and something scary like being pulled over
yep.
by an officer, you definitely want to have that added to the driver's license because when they pull that driver's license up in their little computer, they're going to see that. And so that is very, very important. A lot of people don't know that. I just know that personally because I have added that to driver's licenses for my kids.
Yes, no, and that's a very good point. And because I live in the world of where things don't always go right, I would encourage you also to have something printed out on a bright yellow piece of paper, right? And just have it in the glove box. And then it might just say, I have X diagnosis and it may be difficult for me to communicate. And then you can just hand that right to the officer when they first come, just as another thing, because those licenses are small and those little codes are small. And so I think bright yellow something is a really good way to catch that officer's attention in a respectful way, right? Because you don't want to threaten them either or make them feel like you're questioning their authority. So I recognize that that's a scary situation.
I want
Um,
to make sure we just had this in the chat box that you're going to go a little bit further because we always talk about the lesser restrictive. We talk about full guardianship, lesser restrictive, supported decision-making agreement. But can you spend some time on the partial guardianship and what that means, what rights they retain,
sure.
and what rights they lose in a partial guardianship?
Sure. Let's continue on because I think I have a slide that talks about all the different rights. And so I think that would be a really good time to cover that. Um, So, in terms of when to start working on a guardianship, if your child is approaching their 18th birthday and you are on it, you know for sure that you want to go forward with the guardianship, you can file as early as 6 months prior to their birthday. And I recommend that if you know for sure that you're going to need it. But if you don't, if you want to wait and play it by ear, you can always file later, right? I have people come into my office where their youth is 20, 25, 30, right? And everything has been fine until a new doctor comes along or new health insurance or something like that. And so, absolutely, we can take care of it much later than 18 if necessary. Um, I think the next slide is about who can serve as guardian. I don't think there's any surprises here. It's usually the parents have priority, right? Which makes sense. And if there isn't a parent that's available, then other family members can be considered, such as adult siblings, grandparents, other relatives. Um, Normally, just in terms of co-guardians, parents can be co-guardians, but if they are divorced or perhaps never married, always tell people that the courts, at least here in Bexar County, don't like that. They want to have one person making decisions, and so that there's not fighting back and forth. And so co-guardians can get a little bit tricky. But in terms of um, what the ward prefers, we're always going to be asking the ward, who do you think it should be? Should it be your mom? Should it be your dad? Right. And so we are going to consider that preference. There's
I
also
want to
people,
talk about this divorce situation where maybe the divorce situation isn't as good. And
yep,
then we've got one parent that is contesting the guardianship. And does that just mean that they won't get guardianship? I know it means it just gets a little bit more complicated and more expensive, but I mean, we do see that from time to time where the other parent, no matter what the other parent does, they just want to be difficult.
yep.
So what does the family do in that example?
So unfortunately, what that means is they're going to have a replay of the custody uh, battle that they had when they first got divorced. They're going to rehash all of that stuff again in the guardianship, and the court is going to choose one of them. They're not going to have people who can't work together serving as co-guardians. Um, it is very, very challenging when we have that situation, unfortunately. And it does just become a replay of the whole divorce all over again.
And I would just like to mention, I hope nobody on here is going through a divorce right now, but if you are, my opinion, and you can kind of chime in on this, Anne, is that getting this set up on the front end, meaning like we have wording in our divorce documents of guardianship in the future. Like if we know we have a child with a disability that's likely going to need guardianship in the future, I would say it's a lot less expensive and a lot more of a slam dunk if you get that set up on the front end. Anytime you're going back to the judge and back to attorneys to amend that kind of stuff, it's a lot more expensive than just getting it right on the front end if possible.
No, absolutely. And then this is not on one of the slides, but I'm glad that you reminded me to mention it. If you are going through a divorce or custody situation and your child has special needs here in Texas, you can ask that child support continue lifelong. But you need to have that determination in your custody agreement or divorce decree before the child turns 18. So just keep it in mind. A lot of times, regular family lawyers don't know or they don't ask about special needs situations. And so I'll see a lot of times that it's not included, but it can be. As long as that child's not able to support themselves, you are entitled to have child support continue on lifelong.
That's a very, very good point. And one little step further on that,
Mhm.
if you're getting things set up on the front end as appropriate as possible, if that child support is going to continue post age 18, it is very important for wording to say that that child support is going to be directed to a first party special needs trust. And then that way that child support won't count against them for SSI purposes. And if they're under age 18, they never, most of the families we work with haven't, their kids haven't qualified for SSI. But after they turn 18, they likely will. And if that child support is not going to that first party special needs trust, then it's going to count against them. So those are the two things of what are we going to do for guardianship, child support being directed to a first party special needs trust. Those are two big things. And then the third big thing is child support continuing post age 18 for the individual with the disability. So those are all things that should be on your radar. And to your point, Anne, there are a lot of family law attorneys, but there's not that many family law attorneys that are specifically nuanced and special needs. We do have some recommendations, and the recommendations that we have, they could be hired independently, or you could hire them kind of on a contractual basis that they're going to work with your attorney to get it right. So
Yes.
for people that have already hired a family law attorney and then you sadly realize that they have no background in special needs and you feel like you need to back up and punt, you can still get the right professionals on the team to get it right.
I think that's a really good idea. You could almost have a whole nother training just on the child support and how to handle special needs issues in divorce because it's important to get it right. And generally speaking, child support goes through the Attorney General's office in Texas, but once you get the special needs trust involved, that's no longer the case. And a lot of attorneys just don't know anything about that process. So yes, for sure, it's important to get the right expert on the team. Um, Okay. So in terms of who's not a suitable guardian, some of these are obvious, right? The person needs to be an adult themselves. So if they're choosing a sibling, it needs to be an adult sibling. It can't be somebody who has financial conflict, right? Or any kind of um, criminal background that is at a level that rises to like a felony level or harming a child, right? There's all different kinds of things that will pop up on background checks, and some of them are not so important, like maybe an old DUI, maybe that one we could work with. But if it's a sexual offense or abuse of a child or an adult, you're probably not going to be approved as guardian. So that's just something to keep in mind as you go through the process. Ultimately, the judge is just looking to appoint someone who is trustworthy, responsible, stable, and committed to acting in the ward's best interest. In terms of the steps for the actual guardianship process, the first step is to file an application. It's not just a form, it's a whole process, right? Because fundamental rights are involved, and anytime we want to take rights from people, we need to make sure that they're protected. And so we begin by gathering medical evidence. So the certificate of medical examination is very important. Um, the physician is going to be asked to evaluate cognitive abilities, whether the person knows, who they are, what's their name, where are they, do they understand why they're at this appointment? Are they able to communicate, right? And the reason that we're asking those questions is because the court wants objective medical information about how the diagnosis affects daily functioning. So again, we're individualizing it. The physician is not deciding thumbs up or thumbs down on the guardianship, but they're providing the information that's necessary for the court to make the decision. They're also going to look at reasoning and problem solving skills. Can the person understand consequences of decisions? Can they understand risks? Can they understand a lease? Can they figure out how to pay rent? Can they understand how to get where they need to go using public transportation, or can they drive, right? There's all different things on that CME. And then here, I think if we'll go forward a couple slides, there's one called the ability to make decisions. And that's the one that's going to get to those questions that were coming up about partial guardianship. So there are questions on the CME about whether the person can manage a bank account, right? Can they operate a motor vehicle? Can they vote? Can they make decisions about getting married? Or should they be allowed to purchase a firearm? All of those things are yes, no questions. And so if you have someone who you think is a good candidate for a partial guardianship, you can, if we have yes answers to some of those, then it's going to be partial and say, okay, maybe they can't manage their bank account or their finances, but they absolutely can decide um, about getting married or not, or we think that they could vote, right? So those are where we start to break down the different activities and whether we're going to let them continue to make those decisions on their own or whether they need protection. Right. And so that's how we do all of that in a partial situation. Um, if we're looking at, again, a full guardianship, then there's going to be questions on there about whether the ward can take their own medications, whether they can maintain their hygiene, whether they can shop for themselves, whether they can cook, whether they understand medical situations. And so those are all the ones when I see no answers on those, I know that we're looking at a guardianship, right? Those activities of daily living, right? Can they dress themselves? Can they use the toilet without assistance? Can they cook safely? I see a lot of people now, I can use the microwave, but I wouldn't do a gas stove, right? And so there's always ways that we can accommodate. But those are the kinds of things that you'll see on the CME form. In terms of the partial and total, I think there's an actual slide for this, right? It's if if a person's able to do one thing and not the other, that's going to come out on the CME. And same, there is an attorney that's going to be representing the ward, and they're going to make recommendations as well. So um, the court is going to look over time because guardianship is not just a one-time thing, it's for the life of the ward. And so we're all learning and growing. And so it's possible that while they may not be able to do something today, perhaps 2, 3 years in the future, 5 years, 10 years, right? Things change. And so we always can go back and modify if necessary. Um, in terms of the guardianship process, There are some requirements for the application. We're required to provide notice of the hearing, notice that the request has been filed. And so what that means is that these family members, parents, siblings, the proposed ward, they're going to be served copies of the paperwork by a process server. And that gives those individuals the right to appear. They have the opportunity to participate and share any concerns or insight that they might have. Uh, One of the biggest protections that are built into the guardianship process is the appointment of that attorney for the proposed ward. That attorney is called the attorney ad litem. They do not represent the parents, they represent the ward or the proposed ward. And so they're going to come out and meet with their client. They're going to review medical records. They're going to visit the home, perhaps talk to the school as well. And then they make a recommendation. As a safety net, we have another layer, that's the court investigator. They're going to do a very similar investigation and make a recommendation also about the guardianship. So you can see there are so many layers of protection involved in going through this process because I think we all recognize that taking away an adult's rights is something very serious. And so we don't ever want to make a mistake and do that without going through all these steps. So that's why.
Do you want to
Um,
mention that other sibling? We've seen where families have had a falling out and they're not speaking to one of the siblings, or there's the wayward child. That person is still going to be served, and that kid may come up and say, well, they're the most horrible parents and no, they shouldn't be guardian. That can happen. It doesn't mean that the guardianship doesn't still go through, but all of those kids, the ones that are real happy with you and the ones that aren't, are going to be served. Isn't that correct?
It is correct. And I will say, at least in Bexar County, all these cases go through the probate court. And the probate court also handles what happens when someone passes away to their assets. And so those probate court judges are no strangers to family drama. So they see this day in, day out. And so I wouldn't get too concerned about it. Just know that it may slow things down a little bit, but they understand. And likewise, they even, I see pretty commonly where if there's family conflict, family may be calling CPS or APS out all the time to say, my sister's not being taken care of, or my mom did this, or whatever. And so the judges understand if that comes up in a background check. We just have to be prepared to explain a little bit more about that situation so that the court has the full picture, right?
I have a
There,
couple of questions I want to go back to
yeah, go ahead.
until before we move on. First is, if we have a kid that's over 18, can the divorce decree still be amended for lifelong child support if the individual with the disability has a disability that started prior to age 18?
Hmm. I would say that that is not an answer I don't have an answer just based on that. I need to know a little bit more about the situation. Um, but maybe, I guess,
I've
is the
seen
best
it. I've
answer.
seen it happen. Yes, maybe it's more complicated.
Yep.
But ideally, if that could be amended prior to them turning age 18. But I have seen it happen. But again, you're going to want to work with a specialized attorney on that, with special needs, not your family law divorce attorney that doesn't deal with special needs. So I want to mention that. Then we have
Mhm.
another one that says, what if a person cannot afford a guardianship? So there are some counties in the state, there's actually one out by you. It's not Bear County, but there is one out by you that has free guardianship. And I know Galveston County, you have to live in those counties that have free guardianship. But I always encourage people, most of the attorneys that we know and we refer, I mean, they're a fee for service. There's no question, fee for service. Um, However, I suggest looking up disability rights for your state. I suggest Googling legal aid offices near me, or by county or by your city, and then you'll find those legal aid agencies. I think that that is the best way to go about doing it. And sometimes some disease specific organizations may have financial grants for this type of thing. So whatever the diagnosis is, whatever those disease specific or diagnosis specific organizations, you can check about the financial grants on that as well.
For sure. And I know also Catholic Charities runs a guardianship program with a sliding scale fee basis. I know that here in San Antonio, we have the MAC Center, which is the Multi Assistance Center that has grant money for people who need some financial assistance in paying private attorneys. So there are resources out there. Even if you're not able to find reduced attorneys' fees, you can request that filing fees be waived because the filing fees for a guardianship are five to $600 range, plus paying that attorney that represents your youth is usually at least another $600. There are funds in at least our county budget that will cover those for you. So just to highlight that when you start talking to an attorney, let them know if you're struggling or you're really um, paycheck to paycheck so that you can try to figure out ways to make it a little bit more affordable.
A couple other ones. If the parents are married and they both make decisions for the child, would they both be on the guardianship? Like you could have co-guardians in a married situation you mentioned.
Yes. So in that situation, I would say co-guardianship is appropriate. So that would work. Also, you can have co-guardians if it's like a mother and stepfather, or father and stepmother, right? As long as it's all in the same family unit in the home. So in that case, co-guardian would work.
Okay, and then the other question is, this comes up a lot. I hear this all the time. What will happen if the family cannot come up with an appropriate guardian or like a successor guardian? So let's say it's mom and dad. I several times a month I have somebody say, I've got guardianship of my son, but if when I'm gone, it's it. There is nobody else. I have no siblings. All my family's dead. I've got
Yeah.
nobody I trust enough to be guardian. So I have instructed people in the in the past and present to check with the various places, like if they're thinking about a residential living situation. We're doing a residential topic, I think next week, kind of all the different residential living situations for adults with disabilities. Some of them will and some of them will not take on guardianship of the person. I know that there are professional guardians, but tell us what you would advise family in the event that it's the end of the line, there's nobody else after me.
Yeah. So there are professional guardians. That is an option. They can be paid sometimes through Medicaid. There are sometimes also, if the person is living in like an assisted living type situation, they can have someone appointed in that situation that works for the home. I personally don't like that very much. And I know in Bear County, the judges are nervous about it because one of the most important roles of the guardian is to safeguard and make sure that the person is being cared for appropriately. And so you can imagine if the person providing the care is also the person reporting and watchdogging on the care, there's a conflict there. And so I would say, you know, try to find a private guardian or, sometimes we have families that are not family by blood, right? You may have church family or someone else. Maybe sometimes it's a teacher or someone who's been a therapist who might be able to step in once the parents are no longer able to serve as guardian. But it's a challenge for sure.
We got about just a few minutes left, so we'll keep moving. Are
Yeah.
we still on this slide or do you want me to advance?
We'll go super fast through this slide. So just so you know, guardians, we don't just throw you out there with no training. You can take a class. You're actually required to go through the JBCC to take an online class. It's free. It takes about an hour, but you do need that before the guardianship is granted. They will run a background check on you, and you're required to purchase bond, which is to protect the assets of the ward. So if you go to Vegas and lose all the money, the bond is going to make the ward whole again. So we can go ahead on to the next. Our final step. Okay, so we're getting to the end. The last step is to go to court, right, and prove up the guardianship. Here in Bexar County, we try to make this as painless as possible. A lot of times, your youth will not even have to attend court if the physician has determined that they will not understand the proceeding, right? They can be represented by their attorney only. So they don't have to appear, or they can appear by Zoom. So it is pretty straightforward. After the hearing, you need to sign oath, you need to get your bond in place, and then you'll have your letters of guardianship, which are good just a little bit over a year because you're required to file an annual report. And the way it works is you file your report and then they give you your renewed papers. If you don't file your report, you don't get your renewed papers. That's kind of how they enforce that and keep people up on their annual reporting requirements.
You missed filing the report and you don't get your renewal papers. Is there a way to recover, like a late notice, a late fee, you get it in and then they restore the guardianship, or do you have to go through the whole guardianship process over again?
Oh no. Oh no, no, no. We don't go through the whole thing over
Okay,
again. So I would say
thankfully.
yes, you just file that report even if it's late. And then normally the report goes to the court and the judge is going to review it. If it looks good, they'll sign off on it even if it's late, and then you'll get your letters renewed.
Okay, perfect. We have another question.
Mhm.
Is there any program monitoring or checking on guardians? Like I think of like a trustee where like
Yep.
there's a trust protector, like we can, protect against bad actors or people trying to take advantage of the money that's in the trust. But is there something like that for guardians?
I love this question, and it's right on the slide. So we do, at least in Bexar County, we have what's called a court visitor program. That's where volunteers are appointed by the judge to go out and annually visit each ward that's under the supervision of the court. So they're going to come out to the homes, usually unannounced. Sometimes they will call just to make an appointment and come in, but they are the ones who are overseeing everything. In a guardianship of the estate, there is more monitoring. We have two or three bookkeepers that work with our probate courts that are constantly reviewing the flow of money in and out of estates. But if it's just the SSI benefits and under a guardianship of the person only, usually there's not that much supervision because there's really not that many assets to be worried about. So that's why
Another
I do.
layer that I'm thinking about, because we have a lot of clients that have banks as a successor, basically successor trustee or
Yes.
whatever. Like, at the point that you have nobody else, the bank acts as the trustee
Mhm.
and they come out and visit the ward as well. So even though they're not the guardianship of they don't have the guardianship of the person, but if they come out and visit the ward and they've been, shelling out money hand over fist for the ward and they come and the ward is living in some filthy, terrible situation, they have to report it. Like if the person is in, is a threat to themselves or others or is in unsafe conditions, those people have to report it too. So to me, that's one other layer.
Yep. No, I agree with you. And I think, gosh, I'm just looking at the time. So the next couple slides have to do with what powers the guardian has. And so I think we could probably skip over those. And I don't know, unless people have questions in particular about that. But I do like this slide at the end about what a guardian is not responsible for, because I get a lot of questions about that on the front end where people will say, am I responsible if my adult child does this or that? And the answer is probably not, right? You're not responsible if the ward is making bad decisions, if they're out conducting illegal activities. No, I mean, of course, you're the parent, you care about them, you're going to want to intervene to help them as much as you can, but you are not personally liable for that. Same, you're not personally responsible for paying for the services, the therapies, the group home, right? You're using resources that are available to the ward. So you are not on the hook personally for that. They do not have to live with you. Oftentimes parents do keep their adult children home with them, but if you choose to put a group home in place or something else, that's fine as long as you're monitoring that. There are just some limitations when it has to do with mental health treatment and reproductive rights, which we do not have time to get into, but I'll just put that out there as a nugget to think about when you get into that situation. Ah. Okay. And then restoration of rights. So we talked about this a little bit with partial. Because guardianship is for life, it does have to be flexible and you can always come back and ask to change it and even restore rights. So definitely keep that in mind. It's not forever. I would say always continue services, continue vocational training, because hopefully your youth is going to have a very long life and they're going to continue to pick up skills along the way. So for sure. It's not it's not the end. But this is the end of the presentation. So I did see a question about making appointment with me. If you do want to make an appointment and get around that consultation fee, you can just call my office directly. My assistant will schedule you. Just tell them that you asked it and you were in this presentation. It's not a problem.
Perfect. Well, thank you for being here. There's so many considerations that we're thinking about as they're turning 18.
Mhm.
And I just wanted to take a quick moment. I just put this in there. Everybody's going to get a copy of today's slides and a link to the recording. If you opted in for communication when you registered, you'll get it. If you didn't opt in, we won't contact you per your request. So you won't get the slides and a link to the recording. All of our recordings live on the YouTube channel. Usually within a day or two, it'll be posted. All of our past recordings are out there. And these are just some things to keep on your radar. We talk about it in every one of our webinars, and we've done webinars on every single one of these topics. I always laugh because it's like whatever rabbit hole we go down during one of these webinars, it really could have its own webinar for an hour, and a lot of them do. So this is going to be the upcoming webinars that we've got. You can register for the ones that make the most sense for you. You'll be able to click this link. We have this is our QR code to schedule a free consultation with our firm to learn more about the services that we provide and how we can help you on the journey. But the big thing that I want to talk about, I announced this once last week that we have expanded and implemented an SSI, SSDI application support person. We now have a team that will run point. It's a fee for service, run point on start to finish on your SSI, SSDI application. We have a lot of families that are very, very busy that, they may be in professions that they can't just jump away and be on the phone for an hour and a half with SSI. And if that's you, we can definitely help you with that application process. I think the week of the first or second week in July, we're going to have an entire webinar about the process and kind of how that works. So if you need help with that, let us know. We've put Jessica and her team on board with CPG for that. We've been hearing about this for years that we need to do it, and we just never have, and we finally have done it. So we are excited about that going forward. Thank you, everyone, for being here today. And again, everybody's going to get a copy of the slides and the link to the recording. Thank you, Anne, for being awesome. Reach out to Anne and her team. And maybe you've done a lot of planning. You've already got your legal documents in place. We do suggest that you look at those every, 3 to 5 years. Have them looked at. It doesn't mean you have to redo everything. It just means that you should have them looked at. Laws change, things happen. So reach out to her team and have her look at that. And then there's people that are here that just need to get them set up. They don't have them at all, and they just need to get started with that. So we just encourage people to take those steps and get those things done before the crisis happens and there's something where it's a day late and a dollar short. So we do suggest getting that taken care of. Thanks, everyone. I hope everyone has a great afternoon, and we look forward to connecting with all of you again soon.
All
Bye,
right.
Ann.
Thank you. Bye bye.